Thank you, Mr. Chief Judge, and may it please the court. It's a bit embarrassing, but to exercise candor toward this tribunal, it's pretty apparent that I and my colleagues on the Rules Committee let you down. We failed to scrutinize a revision that we presented to you as an expansion of discovery, but was drafted by a prosecutor seeking to monopolize it. We never intended to rob respondents of the full panoply of discovery techniques. Had we realized that, we never would have approved it. Neither the committee nor this court ever intended to undermine the fairness of the process. But that's exactly what we did last year. Candor toward this tribunal is vital to its rulemaking process and its disciplinary process. Rules must be designed to ensure fairness, not to favor one side over another. The process must be transparent. Participants must be candid. We have no room for hidden agendas. But even as we try to fix what we broke last year, a majority of the committee has continued to favor one side over another. The language before you shields the Attorney Grievance Commission and Bar Counsel from the same scrutiny applied to all other state agencies and officials, and it creates a double standard, treating your fellow judges better than the lawyers coming before you. Accused judges can depose the Judicial Disabilities Commission. Accused lawyers cannot depose the Attorney Grievance Commission. The AGC is the only state agency among hundreds to get this type of special treatment without any showing of any need for special treatment. It is a unique exemption from the same transparency applied throughout state government. An accused judge may depose investigative counsel in accordance with the discovery rules. But if an accused lawyer wants to depose Bar Counsel, that lawyer must meet a much higher burden. The committee note proposed to you doesn't recite Maryland law, it creates Maryland law, taking it right out of Bar Counsel's brief. We spent about 20 minutes on the topic in committee and had a split vote on the issue. That's not something, and that's not a standard that this court should simply adopt on a whim. If there is an abuse in the process, Bar Counsel has the right to file a motion for protective order, just as investigative counsel could in response to a deposition notice propounded by an accused judge. The judicial discipline process is rather transparent. The attorney discipline process is quite opaque, and that's what happens when you let the prosecutor set the agenda of the Rules Committee. I had submitted revisions that mirrored the judicial discipline rules because frankly, I liked them. And there was a major overhaul that this court had approved. And I thought that what was good for judges could be good for lawyers. But that never got on the agenda because, as I was told, no, we've got this. Bar Counsel has already gone through the rules, and those were the rules that were put on the agenda of the committee. We have no room for double standards. When it comes to ethics, we need a single standard. This court can't punish lawyers for a lack of candor toward the tribunal or conduct prejudicial to the administration of justice, but tolerate both on the part of one lawyer who sought to undermine the administration of justice in all disciplinary proceedings. If this court is going to restore the integrity of this system, it's going to need to do more than just change the language of the rule. But what I would say is that I've addressed some of the details of those changes and concerns with those changes in the letter that I submitted to this court. I think it's imperative that this court establish a standard holding all lawyers, including Bar Counsel, to their duty to exercise candor toward this court and to preserve the administration of justice in a fair and equitable manner. And that's all I'm asking. I thank you.
Okay, that was exactly 5 minutes. Thank you, Mr. Kramer. Does anybody on the court have any questions for Mr. Kramer?
Thank you, Mr. Kramer. Can you help me understand what type of information is slipping through the cracks, so to speak? The cracks in the in terms of the information that's already being provided by Bar Counsel under the current rule, combined with all the information that was provided during the process, the peer review process leading up to the filing of the petition. Can you just help me understand what types of pieces of information are slipping through the cracks?
Well, Judge Gould, you have two problems here. One is a problem of image, and the other is of fairness. The judicial disabilities rules contain provisions that ought to be good enough for lawyers themselves. Judges have the ability in an appropriate situation to depose investigative counsel. You're denying lawyers the same right. The Judicial Disabilities Commission, like all other state agencies, are subject to deposition. That's not true of the Attorney Grievance Commission, and there's no reason for this special treatment. Now, I can't tell you that this is the biggest issue. Frankly, the biggest issue was restoring our right to propound interrogatories, requests for admissions, requests for production of documents.
My question is broadly covers all of that. The entity deposition, interrogatories, in other words, what's slipping through the cracks, and just what types of information is slipping through the cracks that you need these other discovery tools to fill out the picture, so to speak.
Well, Your Honor, when you say other discovery tools, how do you mean?
Okay. Under the current rule, Bar Counsel is required to provide its entire record and exculpatory information. So there's a whole bucket of information that the attorney that's subject to the petition is entitled to under the rules as they currently stand. What I'm trying to understand is what type of information is not being provided in that bucket of information that you're trying to augment or supplement through the use of the other discovery devices, including the deposition.
Thank you, and I do understand. Well, as things stand now, I have to rely upon a prosecutor telling me that she has produced her entire investigative file. I'm dealing with a prosecutor, Your Honor, that wants to win at all costs. And candidly, even in the underlying case in the Maryland Pierre matter, the prosecutor has given me a couple of statements of a couple of witnesses, but they're supposed to summarize all oral statements as part of the 19-726 discovery provision. And ironically, the chief witness on behalf of the prosecution is an individual for whom I have no such statement. Right? The problem is I can't trust that I'm getting everything that's been pledged to me.
But let me just interrupt you and ask you, what you're describing to me then is, what it sounds like is you're saying that you don't think Bar Counsel is complying with its existing obligations under the rules. And my reaction to that is there's already a remedy for that in the rules, which is motions practice.
Well, motions practice is fine, except if I don't have the ability to depose Bar Counsel in that situation to figure out who did you speak with, all right? What other individuals did you discuss? And understand the scope of the investigation. I have no ability through motions practice to divine that myself, all right? I need to be able to verify, trust but verified. That's important. But additionally, why are we imposing a higher standard on the depositions of Bar Counsel than we would for accused judges who wanted to depose investigative counsel? The discovery rules provide for protective orders. And on a protective order, this court ultimately can decide what the standard ought to be. But this committee note is simply designed to discourage any lower court from ever permitting the deposition of Bar Counsel. Now, I will tell you that I have never in my career seen a need to depose the entity of the Attorney Grievance Commission. But I can't speak for all cases that might happen in the future. I don't know when I might need to do that, just as an accused judge doesn't know when perhaps they'll need the deposition of the Judicial Disabilities Commission. To take one entity and exclude them, exempt them from government transparency sends the wrong message, certainly, particularly when there's no need for a blanket exemption, for example. And as for Bar Counsel, why are we reserving this language for the attorney discipline process, but you are not going to subject your own colleagues, your own fellow judges to the same thing? And it's not even a standard you've adopted. It's a standard that we came up with in about 20 minutes on the Rules Committee, and not everybody voted for that committee note. So
Mr. Kramer, you still haven't told me what type of information you're not getting through the existing discovery. What's, are you not getting names of witnesses? In other,
No, Your Honor, we're talking about a rule that is designed to fit all cases. Right? Unless you give me a fact pattern and a scenario, it's impossible to answer that question in the abstract, because I need to know the parameters. For example, in the Pierre case, a fellow by the name of Stephen McAuliffe, who's the campaign manager, was designated as a witness. He is the main point person for Bar Counsel's entire investigation of my client. And ironically, even though the rules state, that Bar Counsel must provide me a summary of any oral statements made by this person, I've gotten nothing, zero. It clearly hasn't been complied with, because there's no way that a competent lawyer is going to designate a witness without ever speaking with that person.
If the court please, I want to make just one response to what Mr. Kramer just said, which was not true. Under this rule, a lawyer can take the deposition of Bar Counsel or anyone else but Bar Counsel. There may be conditions on it, which are all in Title IV rather. You may have to show certain things, and the courts are not in total alignment on what they are. But it is not the case that you can never take the deposition of Bar Counsel. This rule expressly provides for that, because it hinges back to the Title IV rule. I have asked permission, and I don't have to do it right now, if you want to take all the other people who are going to testify, to raise a much more serious issue, frankly, that comes from Mr. Kramer and that the court needs to deal with. But I can wait till the end to do that if the court pleases. But with respect to what he just said, it is not so.
I do think that it makes
so.
If I may, in response to Judge Wilner, what I said was, and under the rule as it exists now, an attorney, an accused lawyer, unlike an accused judge, can never depose the commission. And I'm glad that Judge Wilner recognizes that there's a dispute as to what the standards are for deposing opposing counsel, because the committee note itself takes a stand on an issue that this court has yet to take any stand on. And so, in my view, why are we putting language in designed to deter lower courts from ever allowing the deposition of Bar Counsel, but somehow we just don't need that for judges? I mean, if we're going to be fair, if we're not going to go with a double standard here, then why are we approving more stringent language in the attorney disciplinary realm and not judicial discipline? That makes no sense. But in answer completely to Judge Gould's question, there is in the underlying case a real concern that, contrary to what is required of the voluntary disclosure by Bar Counsel, we haven't been given everything. Now, the reality is that I ordinarily wouldn't normally take Bar Counsel's deposition. I had to note it in that case because candidly, Bar Counsel wasn't going to answer my interrogatories or.
Mr. Kramer, I think we're getting kind of far afield from the rules questions here and delving into an individual
Well,
case.
I just, Your Honor, wanted to respond to Judge Gould's question of what information is missing. And there is information missing, but it'll vary from one case to another. And in some cases, there won't be any information missing.